Good afternoon. I'm Jonathan Enton, the academic dean here at Case Western Reserve University School of Law. On behalf of our dean, Bob Rawson, who very much regrets that he can't be here today, Bob is off doing the things that deans are supposed to do. On behalf of the school, I would like to welcome you to this year's lecture by the Rush McKnight Visiting Scholar in Labor Law, Theodore J. St. Antoine. Before I introduce Professor St. Antoine, a couple of words of background. First, the McKnight Visiting Scholar Program in Labor Law is one of the 4 annual programs that our Center for the Interdisciplinary Study of Conflict and Dispute Resolution, SISTER, puts on, and the director of SISTER over here is my colleague Calvin Sharp. I want to thank Calvin for all the work that he's done in putting these programs together and in bringing Professor St. Antoine to the law school. Second, just a brief word about Rush McKnight, for whom this program is named. The Rush McKnight Visiting Scholar in Labor Law program was established in 1997 by the firm of Calfee, Halter, and Griswold in honor of Mr. McKnight. Mr. McKnight headed the firm's labor and employment practice for many years, as well as its executive committee. Before joining Calfee Halter, Mr. McKnight served as attorney advisor to the chairman of the National Labor Relations Board. He is a longtime civic leader and dedicated supporter of the law school. He served as chair of the Law School Annual Fund, president of the Board of Governors of the Law Alumni Association, and is an elected member of the Law School Society of Benchers. Now, the Rush McKnight Visiting Scholar in Labor Law program has brought some of the most distinguished professors in the field of labor and employment law to the law school over the years. This afternoon's speaker adds luster to this distinguished array of scholars. Ted St. Antoine's career as an attorney, law professor, law school dean, legal scholar, and arbitrator spanned more than half a century. He was a member of the JAG Corps of the U.S. Army and a labor law specialist at his own firm in Washington, D.C. Before joining the Michigan Law Faculty. He was dean of the law school at Michigan for 7 years, and I might add, I was a graduate student at Michigan across campus from the law school, and for a brief period of Professor St. Antoine's deanship. A prolific scholar who is the author of more than 150 publications. His works include a leading casebook on labor law and 2 editions of the Common Law of the Workplace, The Views of Arbitrators, as well as some of the most influential articles in the field. Our guest has been a visiting professor at Cambridge, Duke, George Washington, and the University of Tokyo, in addition to his years on the Michigan faculty. He is engaged in numerous professional activities, including reporter for the Uniform Law Commissioners, president of the National Academy of Arbitrators, chair of the United Auto Workers Public Review Board, and chair of the Michigan Attorney Discipline Board, just to name a few. Today, he will address the question of mandatory employment arbitration, keeping it fair, keeping it lawful. Please join me in welcoming this year's Rush McKnight Visiting Scholar in Labor Law, the James E. and Sarah A. Degan Professor Emeritus of Law at the University of Michigan, Theodore St. Antoine.
Good afternoon, and thank you very much for those generous words, Jonathan. I'd like to say a word before beginning my presentation, a word of acknowledgement and tribute to our honoree, Rush McKnight, and the sponsors of this series of lectures. In my experience, most law students sometime during their second year begin to wonder whether there really is any connection between these quaint 18th century English cases that they are reading and the legal theory that is being presented to them, and the hard realities of practicing law in 21st century America. It seems to me that lectures like this should provide some reassurance to students that there is a real connection between legal theory as taught at this School of Law and even those quaint 18th century English cases and the harsh realities of practicing law in 21st century America. And so I think we do owe a debt to the foresight of people like Rush McKnight and the people who arranged for this lecture series in providing that kind of reassurance. As I look around this audience, of course, as I find on most of these lecture occasions, it probably isn't the students who are present that ought to be getting the reassurance, but at least even the faculty and active practitioners should get some reassurance that what goes on in law school does have some relationship to the active practice of the profession. I am somewhat tempted because of this webcast perpetuation of my presentation to tend to read more than usual. But frankly, I don't like reading to people very much. And so at the risk of occasional bumbling about and a few awkward phrasing, I'm for the most part going to talk my presentation through to you. For anyone who wants a smoother English translation of my remarks, I do understand that there is a written text lodged somewhere at Case Western Reserve Law School, and I'm sure they'll be happy to make it available to you on some future occasion. In any event, to get down to business, President Obama's sweeping victory last November and the installation of a seemingly filibuster-proof Congress has obviously encouraged Democrats to come forth with some long-desired legislation that in past years would have been quite impossible to get passed. You probably have heard about the Employee Free Choice Act, which would provide that a union could obtain representational rights without the customary labor board election, secret ballot votes and all, simply through having a series of card checks with employees signing unilaterally petitions or cards indicating their desire for union representation. And then if the employer and the union could not reach an agreement on the first set of contract negotiations after 4 months, there could be compulsory arbitration of the terms of that first contract. This act, which has received a good deal of publicity, would cover perhaps as many as the 35% of the American workforce, which represented the high watermark of unionization back in the mid-50s. I'm not going to speak about that act this afternoon. I'm going to be speaking about another act that is proposed, the Arbitration Fairness Act. The Arbitration Fairness Act, which has received a good deal less attention, but would actually apply to the entire non-union workforce, which roughly at this point represents a quite overwhelming 92.4% of the American workforce. That is to say, all but that 7.6%, which is the only portion now organized into labor unions. The Arbitration Fairness Act would prohibit pre-dispute agreements between employers and employees to arbitrate any kind of dispute arising as part of their employment relationship. And let me set the problem for you, just what this is all about. Let us assume that we have an employee, an ordinary blue-collar worker or pink-collar worker, who has lost his or her job during the current recession. They are presented with the possibility of a job that is paying less but better than nothing. And among the other papers that they are presented with as part of their application process, they are presented with a form which states in effect all disputes between the company and the employee arising out of this employment relationship, including statutory claims, shall be resolved through the arbitration system established by the company, and the employee waives all right to bring any action on such claims against the company in federal or state court. If the employee at that point should have the temerity to ask, what happens if I don't sign this? The answer is going to be quite brief. You don't get the job. So in effect, as the price of getting a job, or keeping a job, as the employer is asking this of incumbents, as the price of getting or keeping a job, an employee must agree to waive the rights that he or she otherwise would have to take an employment discrimination claim to the federal or state courts, and in appropriate cases to get a jury trial for vindication of their claims. The United States Supreme Court, in a famous case decided in 1951 called Gilmer against Interstate Johnson Lane Corporation, the United States Supreme Court ruled in a case involving a stockbroker that an agreement to abide by such an arbitration arrangement was a valid provision and could be enforced by the employer. The Supreme Court pointed out several things that should be noted. First of all, it said the employee was not being deprived of any substantive rights. There would still be a right to freedom from racial or sexual discrimination or other forms of arbitrary outlawed discrimination. It was simply a change of forum. It was simply a change from the judicial forum to an arbitral forum. The court also emphasized that whatever procedures were available would have to be sufficient. They would have to enable a fair vindication of the employee's statutory claims. And finally, this did not prevent an employee from bringing a charge before the Federal Equal Employment Opportunity Commission. It would only deprive the employee. The waiver would only extend to the employees bringing his or her own judicial action in case of an employment dispute. Why did this come about? A little history is necessary here. During the 1980s, courts across the country, in all but a couple of states, introduced some important qualifications upon what has traditionally been the American doctrine of employment at will. Employment at will. Under the American system, most persons outside the labor and employment field are quite unaware of this doctrine. Under the doctrine of employment at will, an American employer can fire an employee for any reason whatsoever unless there is a contract provision to the contrary or unless there is some statutory prohibition. As a matter of the common law, an employer can fire an employee in most states because of the employee's political allegiance, because of a personality conflict, for any reason whatsoever. During the 1980s, as I've indicated, there were a substantial number of decisions by courts across the country introducing some qualifications of that very powerful employer right, based either upon a contract concept, the notion that when an employer at the time of hiring tells an employee, you have a job with us indefinitely, in the absence of misconduct or incompetence, we will not fire you except for good cause. What had previously been regarded as simply a kind of puffing or statement of present policy, not legally binding, courts began to conclude were legally binding, or a statement in a personnel manual, it is the policy of this company not to dismiss anybody except for good reason, could be sent to a jury to determine whether or not that was a contractually binding commitment. And of course, with juries consisting mostly of employees, a lot of cases were won by employees on that basis. Another notion was that the employer could not fire an employee if in doing so it was violating some basic public policy. Employers in the past were able to get away with discharging an employee for refusing to participate in an illegal price-fixing antitrust violation. Even that would not have been sufficient in the past. Finally, this became too much for the courts to stomach, and they began to hold these acts by employers as violations of law and subject to recovery. The result was some very significant awards for employees. In California, one study indicated that employees who could get to a jury won about 75% of the time, and the median award was very close to $500,000. Across the country, individual employees were winning as much as $20 million, single employees, for violations of either their contractual rights or violations by employers of public policy. At that point, many employers began to arrange for what I have just described to you as the kind of an agreement that my hypothetical employee would have to enter into in order to get or retain a job. The employee, I repeat, would have to agree that all disputes between the employer and the employee, including statutory claims, would be subject to arbitration in a system established by the employer, and the employee would waive the right to take such claims, including those statutory civil rights claims, to a federal or state court. Now, you can easily imagine the arguments against that regimen. Congress or a state legislature has prescribed not only certain substantive rights, freedom from discrimination because of race or sex or religion or disability or age or the rest, and they have prescribed a system for the enforcement of those rights, which ordinarily is first an administrative hearing and then the right of the employee or the administrative agency to take the claim to federal or state court, and in many cases to have not only a judge but a jury entertain those claims. Beyond that, there are several specific objections that were raised. The claim that the employer would be much more often the repeat player, would be knowledgeable about the arbitration process. The employee doesn't know anything about this process, and that's tilting the playing field in favor of the employer. The argument was also made that a few sizable and well-publicized jury awards would have a deterrent effect upon employer violators that would not be true in the case of a confidential private Arbitration Award. And it also was argued that this whole arbitration system was a subtle anti-union device. The existence of the arbitration system as a means of vindicating employee rights has often been said as one of the principal selling points of labor organizations. And consequently, the argument is made that if employers establish these arbitration systems, that takes away a major argument for unions in favor of organization. These arguments against mandatory arbitration, it seems to me, are very powerful indeed, but they certainly aren't conclusive. For example, as to some of the specific objections made, one can say that it's true that employers are repeat players, but at least one very reputable study of what's going on suggests that employers win not because they are the repeat players, but because they simply have better cases or they are more knowledgeable, and not because of any arbitrator bias in favor of the employer as the repeat player. It's also pointed out that it's true that a large jury verdict that's well publicized can constitute a major deterrent. But on the other hand, some good empirical studies indicate that much more important than the severity of any sanction is the certainty that it will apply in many given cases, and that frequent arbitration judgments against an employer will have a greater deterrent effect than a few large jury awards. And then the history of this suggests that unions were really at their height in the 50s. They were falling steadily long before employers turned to this system of mandatory arbitration during the 1980s. And that attempts to avoid emotionally aroused juries and the devastating verdicts that they occasionally would come up with, that and litigation costs were a much more significant factor in the desire of employers to establish mandatory arbitration than any efforts to avoid unionization. It seems to me that ultimately the determination of whether mandatory arbitration is or is not overall the kind of permissible arrangement that the courts should enable to continue is a matter of empirical demonstration. What really goes on in fact? And this, I think, is the way the judgment should be made, and not on the basis of a priori preconceptions about the goodness or the badness of this facially offensive system where employees are faced with the draconian choice between getting a job and waiving their rights under various statutory civil rights provisions. First of all, it doesn't do much good to have a statutory claim unless you can have reasonably accessible means of enforcing that claim. So the very first question to be faced is how accessible is the statutory procedure that, on the books at least, is available. And here there are some very interesting statistics. A very good friend of mine, a leading employee lawyer in Detroit, reported to me that his secretary actually kept count. He accepted 1 out of 87 persons who came to his office as an employee seeking some kind of a complaint against his or her employer. A little less dismal is an overall figure that was presented by a plaintiffs group, the National Employment Lawyers Association. At one of their conventions, they came up with the figure that they provided employees representation in about 5% of the cases when such representation was sought.
Was it a contingency fee? That's what we thought.
Yes.
Not if the guy would pay, then they would.
The lawyers are always willing to accept any client who is prepared to pay. Thank you for the qualification. We're talking about the rank and file employee who marches in not able to pay the lawyer, but the lawyer relying upon a contingent fee if the employee's case is successfully concluded. And what I think is one of the most comprehensive studies of this whole question, Professor Alex Colvin of Cornell has declared that one of the key potential advantages of employment arbitration over litigation is that the relatively high costs of litigation inhibit access to the courts by lower to mid-income range employees, the ones who don't have the wherewithal to pay the lawyer, and the lawyer must rely upon the contingent fee. Another study indicated that there's a kind of line to be drawn, that essentially employees making less than $60,000 a year, employees making less than $60,000 a year aren't going to be able to afford a lawyer and must rely upon the contingent fee compensation arrangement. The last time I looked, the median income of employees full-time, year-round, in the United States was a little over $40,000. So you can see that the vast majority of employees are not going to have access to a lawyer based upon contingent fees. A chap named Louis Maltby, president of what is now called the National Work Rights Institute, has long opposed mandatory arbitration. Nonetheless, at a conference sponsored by the National Academy of Arbitrators a couple of years ago, he reported upon his experience as the director of a task force for the American Civil Liberties Union. He was flooded with requests by employees for assistance when they believed they had claims against their employers, usually for wrongful discharge. Lou said that most of these cases, in fact, as he looked at it, were not winnable. They weren't meritorious cases. And yet he did come up with about 2 or 3 dozen that he did think merited pursuit. He then sought to obtain lawyers for these particular employees. The ACLU precluded him from the job that he was in from handling them himself. Despite the pre-screening that this expert engaged in, he could only find representation for one single employee. Now, again, I repeat, I think in many, if not the majority of these cases where representation cannot be obtained, the employees probably have losing cases. But the fact is that even when it is a claim that has life to it, that is worth pursuing, only a relatively small number of employees can get a lawyer to take that case, again I repeat, with the qualification and with thanks, on a contingent fee basis. Employees are not necessarily going to be held by the Equal Employment Opportunity Commission. The commission is underfunded, it's understaffed, and it really can maintain only major cases or significant test cases. One very savvy commentator has actually proposed that the EEOC even get out of the business of trying to deal with routine cases and confine its efforts and so announce it to the significant test case or the big class action situation. The second thing, that's the first point, that the ordinary rank-and-file blue-collar employee, pig-collar employee is going to have considerable difficulty securing access to relief through the courts. And arbitration, which is much cheaper, should be faster, certainly simpler, much less intimidating, as a place to which an employee can go either with a lawyer that does not have to expend anywhere near the effort preparing a federal case, or by himself or herself, or at least with a friend to handle the case. At least they can make a presentation, pro se as we call it, by themselves in arbitration, which they simply, in most instances, would not have a genuine chance of doing in a federal or court suit. The second point is, how do they do in arbitration? Remember, these are systems that are established by the employer. And one can certainly argue, as many academics have, that this is a stacked deck. The employer has set up the system. The employer is going to have control of it. And how much will these arbitrators be truly ready to decide the case in favor of the employee? Well, in my material, the written material, I have set forth a series of statistics from half a dozen what I regard as highly reputable studies by a swath of academic figures from the Cornell, Indiana, New York University, South Carolina. The individual names would all register with members of the academic specialty of labor and employment law who have put these studies together. The General Accounting Office is another body of high repute that has made such studies. I will not try to inundate you with the statistics. And if this is one point where my old-fashioned resistance to PowerPoint unfortunately lets you down, this would be the right time to run these figures by you. I'm going to simply try to combine a few of the figures, some of the array of them, and I trust you will be able to catch it. I should point out at the beginning that one of the things that has been discovered is that there is a very real difference both in court and in arbitration between the individual highly paid employee, the TV anchor, the football quarterback, the high-ranking business executive who has entered into an individually negotiated arbitration agreement with his or her employer. The winning percentage for those persons is invariably higher than the winning percentage for the lower-ranking, lesser-paid employee, who is probably relying not on an individual arbitration agreement, but rather upon an arbitration provision set forth in a personnel manual, employee handbook, that kind of generalized pronouncement to the workforce by the employer. Now let me just give you the range of some of the figures. For the lower paid employee in employment arbitration, the lower paid employee, the winning range has been between about 21% and 40%, from 21% to 40% for the lower paid employees. For the higher paid employees, the winning range in employment arbitration is between 40% and 69%, 40% to 69%. That is contrasted with court litigation, which presumably for the most part consists of the more highly paid individuals, the one who can afford to get to court or who has a very likely prospect of winning. In the courts, the percentage ranges from 12% to 57%. Notice the lower end is lower than the lower end of that arbitration, 21% even for lower paid employees. And it is just a little lower at the higher end, 57% to the highest in the employment arbitration range, which for the higher paid employee was 69%. So on those bases, there is a preference, it seems to me, for arbitration. I found this astonishing. I did not expect it. I regard it as a bonus. Yes, ma'am.
Do those figures bear out what settlements might have been achieved through litigation, or is that just court mandated result?
Each one is in itself. We obviously have to speculate what would be, if the same cases were tried in both forums, what would be the results, but that's not the way things work. They're one forum or the other. And we always have the problem of, are we comparing apples and oranges? Of course. But again, when you consistently see these patterns by people who have no axe to grind, it seems to me they definitely carry significant messages. Let me give one that I might, yes, sir.
What you're saying is, by winning, the definition of winning is any judgment amount. Is that?
Yes.
The definition?
Not settlements and not summary awards.
Any dollar judgment.
Yes.
That's what you mean by winning.
Yes.
But the issue is how many dollar votes, and that's you're talking about. One is a quantitative thing, just saying a yes or no, and then quantity is also another issue. The problem.
Fair enough. Winning plaintiffs in the courts get higher awards than in arbitration.
I wanted to complete my question.
Of course.
Because obviously.
I was only trying to agree with you.
Excuse me, could I just make a suggestion that we could let Professor St. Antoine do the lecture? We'll have an opportunity for questions afterwards. But especially,
well, let's get this.
Also
let's get
because
this.
we're being webcast, it's really hard for the, okay?
But I think
Let's get this one answered.
I'm agreeing with you, and I'm not trying to disagree at all, just trying to clarify it. Once you get into court, the dollar votes just to get into court and take this thing all the way through to the court is gonna be hundreds of thousands of dollars. So any judgment may not be a judgment. You still would lose if it was under a couple $100,000 judgment, because your legal fees will be hundreds of thousands of dollars.
That point is entirely true on both sides. For something that I omitted from my rambling presentation, instead of sticking to my text, is that employers who win, the figures indicated, this was in the around 1990 when I made a survey of my own among employers council. In the Midwest, the winning of a jury trial usually ranged between $100,000 to $150,000 in costs to winning defendant employers. On the coasts, that figure was over $200,000 on average, according to my employer informants. I assume that today those figures would be the greater increase that we have seen in the cost of living and so on. One of the comparisons that, interestingly enough, I have not seen made is the comparison between success rates in employment arbitration, which I've just given you, and success rates in which many people would regard as the gold standard of arbitration, namely labor arbitration, arbitration between unions and employers. Now you have a union prepared to represent the employee with all the knowledge of the workplace, the practices of that employer that a union brings. I myself made a survey of 200 discharge cases handled by what I think the country would regard as one of the most respected, long-lived union management arbitration systems in existence. Out of those 200 cases, the employees received some meaningful release in 43 cases. That is only 23%. In only 23% of labor management arbitrations in this particular system did the employee win. That is a lower winning percentage than in all but one of the employment arbitration surveys of these half dozen or so that I previously mentioned. So from whatever way I look at it, it does seem that both in terms of access to a tribunal and in the results, employees are indeed better off having available to them, however flawed the system has been in the past, the arbitration system rather than the theoretical availability of court with judge and jury. Now, for me then, the most important part of this process for the arbitration system, for maintaining the validity, the fairness, the legitimacy of the arbitration system, is providing for due process. That is to say, fair procedures for the employees. A couple of groups, the Dunlop Commission on the Future of Worker Management Relations, and a widely diverse body sponsored by the American Bar Association, but including representatives of employers, the unions, the ACLU. This group, these two groups, came up with very similar standards of due process. They consisted of as follows: a jointly selected neutral arbitrator who knows the law. Second, simple, adequate discovery. Third, cost sharing to ensure arbitrator neutrality. Interestingly enough, my former colleague, Judge Harry Edwards on the D.C. Circuit, in an opinion that I think really has commanded the day, concluded that this third requirement, cost sharing to ensure arbitrator neutrality, was a mistake. That arbitrators do care about getting their money, but they don't care where it comes from. And what makes a much greater guarantee for the employee is that the employee should not have to pay any more for using the employer's imposed arbitration system than the employee would have to pay to get access to an appropriate judicial tribunal. And that now seems to be the approach that's being followed by a number of academic commentators and recently the National Academy of Arbitrators. The other due process rights: the right to representation by a person of the employee's choice, remedies equal to those that would be provided by the statute, a written opinion and award with reasons, and finally a limited judicial review, largely emphasizing legal questions. More recently, academics and the National Academy of Arbitrators have come up with a few other due process provisions they feel should be imposed. There should be no shortening of the statutory provision for limitations on bringing actions, the period of time after the action dies, no shortening of that period. There should be no prohibition of class actions if a class action is necessary to vindicate the statutory claim. This would be especially important when the claim for any individual is relatively small, like a wage claim under the Fair Labor Standards Act, but which would be very meaningful if a substantial number of employees could join and seek that same kind of right. And scheduling of hearings should be at a convenient place and at a convenient time for the parties. Some quite distorted provisions have required the employee to bring the action, an arbitration action, far removed from the employee's place of residence. Well, that concludes my overall presentation. For me, there is a choice here to be made between what, on the face of it, is a noble but abstract principle, and that is that no employee should be required to give up the right provided by a statute for judge and jury as a means of getting or keeping a job. That's the noble but abstract principle. The harsh reality, as I think reputable empirical studies have demonstrated, is that in fact employees are better off, especially the lower ranking blue collar, pink collar employee. They're better off having accessibility, and accessibility comes much better through an arbitration provision subject to the kinds of due process protections that I have just briefly mentioned. That is the better practical solution. And I have to confess that for me, if it's a choice between an abstract principle, no matter how noble, but one that is not reflective of reality, then I'm myself happy to proceed with the facts. And in that case, that appears to be mandatory arbitration. And I very much hope, I fervently hope, that the Congress and the concerned public will deal with this whole issue, with that harsh reality, the superiority in fact of arbitration over the theoretical availability of litigation, will make their judgments on the basis of that finding foremost in their minds. And I thank you for your attention, and I'm very happy to answer questions.
Now, I am ordinary, do we have a handheld mic here? My concern earlier was, because we're being webcast, it's hard for the people who pick this up on the web to hear the questions. And I don't see a mic, but first, St. Antoine is going to take some questions. Because we don't have one, you may need to summarize the questions before you answer,
Yes.
But I apologize.
If I can hear them.
Okay.
Yes, sir.
Two questions. First, what's your prediction on the arbitration turns out? What are its prospects? And two, what's the status of removal of cases that have been brought originally in state court and under the Federal Arbitration Act for removal to federal court?
An awfully good question, and I really have to plead ignorance. The American Arbitration Association, which I like to think has a good deal of credibility in the eyes of Congress, is opposing the elimination of mandatory arbitration and calling instead for a whole series of due process protections. The National Academy of Arbitrators, and one might think that the National Academy would be automatically in favor of arbitration. In fact, its official policy opposes or has opposed mandatory arbitration in the past. The National Academy of Arbitrators, in keeping with a long-standing policy of the last half-century not to propose or oppose legislation, doesn't take any position on the Arbitration Fairness Act itself, but does say that if Congress is going to permit mandatory arbitration, then it should provide by legislation for the enforcement of the kinds of due process standards that I've just discussed. So we've got two very significant bodies, one of which is not coming out in favor of mandatory arbitration, one of which is not opposing mandatory arbitration, the other of which is saying it's all right as long as there are due process protections. I hope the Congress pays attention to these bodies. I really think that many of the people who are engaged in reactions against it are doing it because on the face of it, it's outrageous, but they aren't paying attention to what goes on in fact. Yes, ma'am.
Could you just clarify these ranges that you provided? What does it mean to say that the win rate in court is 12 to 57%? That's a huge range. Where did that come from?
Those are different studies. Those are different studies. Some study said 12%, another said 59%. Or if that's the
57.
Right, whichever. And that's true of all of those figures. Each of the range simply indicates the differential in different studies. And that, of course, suggests we're dealing with something that isn't that plainly nailed down. Yes, sir.
You want me to speak in the microphone?
Let me see if I can be clear on this question. Considering the facts that you mentioned, that out of all the cases that went to all these attorneys that you knew, less than 5% were taken on a contingency. Did I hear you correctly?
Yes.
If that is true, and you said way less, really. I mean, I'm taking 5% as a ballpark number. If that's true, there really is no, for people who don't have money, there's no necessity to have mandatory arbitration. They're precluded from real trials by finance. You know, because they can't go to a lawyer and pay him, and a lawyer won't take it. So perhaps a system would be you can have mandatory arbitration, or if you prefer, you can have your typical jury trial rights, whichever the employee chooses at the time. He has a 30-day window to make a choice. What that enables is the person who has no money, or excuse me, who has less than the $100,000 it takes to step up to the plate to play, and it takes a minimum of $100,000, which you also stated, will have to choose arbitration. And somebody who is highly compensated, and it's not only the athletes, there are other people, and I'm very familiar with them because I happen to know one very well, and who has spent much more than the $200,000 on this kind of a claim, and it's the worst mistake I ever made in my life. That said, they have the choice to go to common pleas court without playing this arbitration game that's set in your contract. Mandatory arbitration then required Court of Appeals many times because of that arbitration issue, because you're dealing with a huge corporation that makes you go through the Court of Appeals 10 times before you even get to the jury trial. And then things may even get bifurcated, which we're not going to go there. But I want you to comment on that, because there's a lot of more issues.
I personally would have no objection to giving the employee the option of the two. My assumption is that employers are not going to buy that approach. They want to nail down the employee with the big claim, the employee with a big claim, as well as everybody else, and maybe most especially
You're
the
right.
employee with the big claim that they must arbitrate, and they can't go to court with that runaway jury awaiting them as the employer would
you're
look at it.
absolute-
Now, if there are employers here, they can speak up for themselves.
You're right.
But-
I totally agree with you, but we're going back to your philosophical side now rather than your practical.
But from the practical side, of course, I would like a system that provides the greatest good for the greatest number. And I have to confess that my greatest concern is for that lower paid rank-and-file employee. Pardon? He or she can have a choice, but I suppose the employer could, if he's so willing, he could say that all the employees making less than $40,000 a year can have the option of arbitration or jury trial. I would have no objection to that. But again, as to whether it's something employers would, let me make one further comment. I find this a bit of an, there are two comments that I should have made that I think are both terribly interesting. One of the studies, remember everybody is arguing who is opposed to mandatory arbitration. You are depriving employees of their right to get satisfaction of civil rights claims, statutory claims. One study indicated that in fact only 20% of the arbitration, this was a large sampling of cases administered by the American Arbitration Association, only 20% of the cases actually dealt with statutory claims. Nearly all the others were contract claims based upon these employee personnel manuals providing that the policy of the company was not to discharge or otherwise discipline except for good cause. In other words, in fact, in order to get mandatory arbitration, a great many employers are providing a right that they do not have to provide. It goes beyond the statute. It says we won't discharge you without good cause, without some affirmative reason. And that if one is worried about maintaining statutory claims, only 20% of the arbitrations involve it. The other irony that I encountered just a few months ago at a meeting of Michigan labor bar attorneys, a speaker, one of the top management lawyers in the state of Michigan, said he is advising his clients to eliminate mandatory arbitration. 3 reasons. The employees win too often. I want summary judgment, and arbitrators ordinarily do not give summary judgment. And when I lose, I want the full right of appeal to the courts of appeals. And arbitrators traditionally are reviewed only on very limited grounds in the courts. It would be the ultimate irony if it turned out that this entire process becomes moot because employers are turning away from it. In the bellwether state of California, I understand there is some movement in this direction, but mandatory arbitration there still remains quite popular. Yes, sir.
Professor, isn't there another benefit to the arbitration process that you didn't, you almost touched on that last comment. Are you aware of any studies of how many cases are dismissed or delayed through appeals before actual trial in court rather than dismissed on motions as compared to arbitrations? I know there's some motion practice in arbitration, but it's
very limited.
Very limited. And the same thing with appeals.
That's a very good practical point. The one person that I know of who has commented on this expressly is this Alex Colvin, a very able faculty member at Cornell. Colvin commented that one of the problems that's hard to assess in the courts is that employers probably settle the strongest cases for employees before there's any trial. They settle the strongest cases for employees. On the other hand, the courts grant summary judgment that eliminates the less lesser meritorious cases. So they never get to trial. And thus, just looking at the trial results, arguably may be either over or under assessing the likelihood of employee success in a court action, at least in the federal courts. And I don't know anybody who has really tried to work out that equation. But it does suggest that there are counterbalancing factors in the court litigation.
And one last question, and then we'll have to break.
Professor, do you have any statistics on, or have there been any studies on how many people lost their arbitrations because they didn't have the money to pursue it?
Well, I don't. I'll do note that it doesn't really take much money to pursue an arbitration case. I've handled no more than 5 or 6 myself. I'm not an expert. But I have had a couple of employees come and make a presentation on their own. Now, the fact is both of them lost it. I like to think they deserved to lose it. They obviously didn't make as skilled a presentation as a lawyer would, but at least they could get to arbitration. Employers generally bear the arbitrator's costs. In my instance, they bore the full arbitrator's costs in the cases I handled. So the employee does not have to put any money out necessarily to get representation, can handle the case all by himself or herself.
Okay, thank you very much. Before we break, there is going to be a reception behind us in the lower rotunda where I know there are a lot of questions we didn't have time to get to, and maybe you can pursue those individually.
I'll be happy to deal with it.
Before we do that, I have a little goodie bag here to present to you on behalf of the law school, and because we're running a little over, I'm not going to fish this out, but there are some things in here to commemorate your being here, and we want to thank you for a tremendous program.
Thank you very much, Joe. Appreciate it.